Provision bench item 1, pro remote VC, criminal appeal J 3/23.
For reasons mentioned in the judgment, the appeal is allowed and the impugned judgment and order is set aside. The appellant is acquitted of charges under Section 4 and 6 of the POCSO Act and under 376 of the Indian Penal Code. The appellant shall be set at liberty forthwith unless required in connection with any other case.
Oblige, your lordships.
Yes, your lordship. The Canadian authorities are willing to give them refugee status. So for that purpose, we have filed this interlocutory application. If it may be listed.
Give it to the court master. All other prayers for listing, please give it to the court master.
Item number 5, pass about this matter for this day.
5 is 2017 matter.
My lord, my senior is chamber is shifting and file is missing, my lord.
Okay.
When will you
Keeno,
retrace the file?
yeah, all robo like one.
How long will it take for you to find the file back?
My senior 80 short.
Okay.
Next week.
List after a week is paid for by land council for the petitioner. Okay. But try to find out, we don't know the address of Sherlock Holmes. Correct? We don't know, you'll have to find out the address of Sherlock Holmes and get your file. Okay, next.
Please, Lord, I'd like to mention item number 9. My senior is not in Guwahati, madam. It's left for Delhi for some work, man. You kindly be.
This is a review matter.
Yes.
We don't need any assistance here.
Sit for hearing.
No, this is for hearing, but we don't need any assistance. Wait for the calling of the matter. Then we'll consider.
Item 1 for motion.
Please, your lordship. In this matter, lordship, petitioner number 1 was already declared surrender. Within the stream, and he was directed to
Yes,
register.
what is the status of registration?
Yes, lordship, he registered on lordship 21/9/2016 lordship.
16.
Yes, lordship, 21/9/2016. He was registered and report come before the concerned SP lordship on 27/9/2016.
Mr. Sharma, what is the trend of the judicial orders of the court in such matters? Because once the once he is registered as a he registered under the this Foreigners Act, then perhaps they can't be
For 10 years, his voting rights are curtailed,
So
lordship.
what happens to the order? It becomes infructuous. The opinion of the tribunal
There are two petitions.
will have to be closed.
Once
Sorry,
Once
will have to
registered,
be
then becoming
put into oblivion.
it's only petitioner number one or both the petitions?
No, only petitioner number one.
Two.
So
Two petitions.
regarding petitioner number two, lordship, page 35,
Okay.
let him contest the case, lordship.
Okay. Yes, Mr. Chaudhary. For number two, what do you say?
Petitioner number two, is the son of petitioner number one, lordship.
Oh.
So once his father registered lordship, petitioner number two is the son of the petitioner number one, lordship. Okay. But lordship, notice was sent to both the parties, lordship, both the petitioners.
Page 36.
I have annexed, lordship.
His petitioner one is registered as a foreigner.
Lordship.
Yes.
And
Presumption,
lordship, after 10 years, he can cast his vote.
it's a different issue. So let the petitioner number two also go and register.
Lordship.
Just to find.
One.
My lord, the corollary, the principle should be same in the both cases. One thing is that, my lord, as your honor lordship has already seen in numbers of cases, if the father is declared foreigner, there should be separate proceeding against son also. So if the father has registered himself, then it has to be proved by the son that yes, he is my father. Then only he will get the benefit. Then the proceeding has to be separated
No,
from.
but Mr. Payang.
Yes.
We accept your proposition, but you see, when once the the inquiry started,
Yeah.
in the inquiry, the name of the father is mentioned. So he does not have to prove anything. The state has proved that.
No, my lord, it is also settled, my lord, only mentioning in the enquiry, because, my lord, during inquiry, my lord, while inquiry, the inquiry form is recorded on the basis of their statement only. It is not a proof, or it is not evidence, my lord.
Opinion is only against the father.
Yes.
But
So in that case,
notice was against both father and son, lordship. Page 34, your lordship, kindly see annexure 10. That is the notice served to the petitioner number one, lordship.
No, but you are challenging the opinion on page 24.
I'm not challenging, lordship. Page 24 already he was declared, lordship.
Hmm.
I am challenging
35.
that in spite of
35.
having my name registered, again they have served notice, lordship.
35.
Okay.
Page 24, I am not challenging, lordship. As
He's
per
challenging page
this
35.
direction, I have already registered, lordship. There are some delays, so I have preferred one writ petition before this court. And during pendency, I was directed by this honorable high court to register my name, lordship. Accordingly, I have registered petitioner number one, lordship. Then thereafter, that writ petition was disposed of, lordship, as my name was already registered. Then again, they have sent a notice to the petitioner number one as well as to the petitioner number two, his son, lordship. So I am aggrieved by this, lordship.
My submission is that, my lord, page 35 is the notice served to the petitioner number one, who has registered himself as a foreigner before the FRR. So that notice may go, my lord, because he has already registered. So with regard to second notice, my lord, page 36, 37, that he will have to prove his own case in the tribunal itself.
In the notice itself, my father's name was written, lordship, page 36, annexure 11, lordship. After inquiry, when they came to know that I am the son of Muhammad Abdul Kalam, lordship, then notice was served, lordship. This is again an harassment to the son of the petitioner, lordship.
No, but son is not registered.
No,
Son is not registered.
father registered lordship, so automatically lordship, he will also entitled for the benefit from
Where is this order dated 7/9/16 of the High Court to directing them to register?
lordship. That is page 29. 30 is the relevant portion, lordship.
What is the name of the son?
His lordship. Anwar Hussain, lordship, page 11. So page 36, annexure 11, lordship.
Same. In which document do you find his name?
Page 21, annexure 5, lordship. And his voter identity, lordship, I have annexure 6, page 23.
What is the provision to which the registration needs to be done?
Lordship, 6A, lordship,
6A of
6A,
this-
subsection 3 of 1955 Citizenship Act, lordship.
So what is the procedure?
As per subsection 3, lordship, subject to the provisions of subsection 6 and 7, every person of Indian origin who came to Assam on or after the first day of 1966, but before the 25th day of March 1971 from the specified territory, since the date of his entry into Assam has been ordinarily resident in Assam and has been detected to be a foreigner, shall register himself in accordance with the rules made by the central government in this behalf under section 18 with such authority thereafter in this subsection referred to as the registering authority, as may be specified in such rules, and if his name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted therefrom. And thereafter, lordship, as per subsection 5, a person registered under subsection 3 shall be deemed to be a citizen of India for all purposes as from the date of expiry of a period of 10 years, lordship, from the date on which he has been detected to be a foreigner. So after registration of lordship, 10 years from the date of registration, he can cast,
That
he
is
can
so far,
enroll his name.
that is so far as the person
Petitioner number
who's
1,
registered is concerned.
lordship.
What happens to his family?
And
Relations?
lordship, once he is a registered lordship, he will become an Indian citizen, lordship. So the entire family will become his lordship. Citizenship benefit, they will also entitle lordship.
Your lordship may kindly see the, my lord, section 5 of the Citizenship Act, my lord. Their citizenship by registration is there. Subject to the provision of this section and such other conditions and restrictions may be prescribed to central government on the application on behalf of registering as a citizen of India and any person not being illegal migrant. In fact, here it may not apply because they are illegal migrant, but there is under special consideration, they are registered. 6C.
So once there is no dispute that petitioner 1 is registered.
Yes, ma'am.
Now the question is whether the benefit will be conferred. Similar benefit is to be conferred on petitioner 2.
First June 56, then
Entered in both. No, but there is no finding that both of them came together or you informed him. Okay.
Mr. Pai,
My lord,
please come to page 28
of the, my lord,
of the
writ
brief.
petition. Writ petition.
Yes. This reference is answered by declaring that he is a foreigner between first day January 66, but before 25th March 1971 stream.
Yes,
Correct.
yes.
Now, as per the proceedings before the tribunal, in 2010, when the reference was made, Anwar Hussain was stated to be 22 years old. If he's 22 years old, he would be born sometime in this 1988. So, question of him being a foreigner before 71 stream.
My lord, I'm sorry, my lord, as we have not challenged this opinion. So. we
No,
are
no,
unable
it's
to-
not a question of
Yes.
that.
But
But
that is an absurd,
we are on facts.
that is an
On
absurd situation,
facts,
my
it
lord.
is 25th day of March.
Yes, yes.
Now you see,
Apparently, that is an absurd situation, my lord. It cannot be.
yes, now you see,
Apparently, it cannot be.
Which is an absurd situation.
No, my lord, if he was born in 88, he cannot come before 71.
No. So it presupposes that perhaps he was born here.
My lord, that is not his pleading.
so, because father came in. Father came in, that opening is attained final day.
Yes.
So father came into India. We are unable to accept that he will go in Bangladesh and have his child born there and come back again.
Come back.
There was no proceeding against the petitioner too.
Petitioner to initially, my lord. Now the notice is issued, he is challenging the notice, my lord. So that's why I'm saying, my lord, my submission is that, yes, there against the petitioner number one, my lord, the notice may be set aside as because already he has registered on the basis
No,
of a
no,
notice.
there is a proceeding against this
But
Anwar
cannot-
Hussain. There is a proceeding.
Yes, my lord, that is second proceeding, my lord.
Anwar Hussain,
Yes.
there is no proceeding, lordship. Only notice was served to the Anwar.
No, there is a decision here. I find that there is a trial court, there is a common order of 27/4/2020. Here is the trial court record. I'm putting a flag here. Just check up.
Yes.
This is the trial court record.
Maybe.
Just
Maybe, my lord, that
later
may be
on,
finalized.
After
also.
filing of the. written
After filing of the
statement.
petition,
know.
that
I have
may
not
be
checked that.
finalized. Also.
There was no stay.
There was no state.
No stay.
So then.
178. Fine. 27, 4, 22.
This is 2019. What is the date of opinion? 2020.
2020, lordship.
No,
So
27
this
for
is the
2020.
success you withdraw this and
Yes.
file it again.
Lordship, that information I have not received, lordship.
There in the record.
This state the
Lordship.
record.
Lordship, just now. I
Just
have
check up.
received.
Just look at it.
That's over there.
No, his name I have flagged. This is Chaudhary.
Lordship,
His name I have flagged.
lordship,
I have put a tick mark
lordship.
against his name, number 2 or 3. His name
Sir,
is there, number
Abu-
2.
Lordship.
So there is a proceeding and there is a opinion. He's been declared to be a foreigner post 25/3/1971. So we close this matter.
Yes. Lordship.
Please pass on the record.
Declared foreigner. No, he was declared foreigner, lordship.
That's what I'm saying. Now I have to challenge that
Lordship.
opinion.
That was not within our knowledge, lordship, as there was no
No,
state.
that's okay. I don't blame you.
In respect
But
to
this
petition
is-
number one, your lordship may set aside.
I will.
Second to petitioner one was.
Manur Ali, Anwar Hussain,
Abul
And
Kalam's
also the
name was not
number
there.
Jeevan
Some other persons are also there.
Abul Kalam.
Petitioner number one is Abul Kalam.
Dia Begum, Fatima Khatun, Atas Ali.
It's only. Correct.
This one, okay.
I get a case number 178. 178. That's it.
Mr. Thank, please see the order.
Yes. It's 1784 is also included. Whether my lord 1784 is also disposed of in that case.
Which one?
Reference file.
That common order whether includes the name of petitioner number one.
No,
also?
no, no.
He
It's
is
not
not
there.
there, lordship. I think
It's not there.
against Anwar Hussein's name, his name is there, lordship. Abul Kalam. Right.
Heard Mrs. R. Chaudhary, learned counsel for the petitioners. Also heard Mr. J. Pang, learned standing counsel for the foreigners tribunal. Mr. G. Sharma, learned learned government advocate appearing for the Home Department, and
My lord, both of us appearing in the same department.
Huh?
Home department. We are for the home department.
for the Home Department.
R Talukdar
Mr. R. Talukdar, learned standing counsel for the
Common advocate for respondent number 3, my lord.
government advocate appearing for respondent number 3, and on behalf of Arkady Chaudhary. R. Sir. Miss, write your name and give it. So and so, the council appearing on behalf of Mrs. R. Devi, CGC, and who is appearing for election commission? T. Pegu, standing counsel for the election commission of India. The learned counsel for the petitioners has submitted that pursuant to order dated 7/9/2016 passed by the division bench of this court in WPC 5174 of 2016, the petitioner number 1 has registered himself before the registering authority under the Citizenship Act, 1955 on 21/9/2016, wide registration number R-6106. Full stop. In this regard, the learned standing counsel for the Home Department has confirmed that the petitioner name, number 1, namely Abul Abul Kalam Kalan, has registered himself before the where foreigners registration. What is the name?
FRRO, my lord. FRRO.
FRO, Foreigners
FRRO.
Registration Office.
FRRO.
FRRO. Nagaon.
Nagaon.
Nagaon. Full stop. Full stop. It is also submitted that the consequences of the petitioner number 1 being so registered would follow. Next paragraph. Next paragraph.
Then this provision for, we get all the rights. The 10 years.
It is because of this regime. Because of this hosting sufficient. I think
You're referring to this statement.
So this is regarding to the purchase.
No, this is not even challenge. What is challenge is subsequent notice. In terms of this, he is registered.
Next one. Insofar as the petitioner number 2, namely Anwar Hussain, is concerned, from the record, from the trial court record of the Foreigners Tribunal Jorhat, it is seen that as against the petitioner number 2, reference being case number FTG, full stop 1781/2011, was registered and by a common order dated 27/4/2020, the Foreigners Tribunal, Jorhat has given its opinion, declaring the petitioner number 2 to be a foreigner who has really entered into the territory of India within Packet Assam after 25/3/1971 without any valid document. Next one. The Learned Counsel for the petitioners has submitted that the present appeal was filed on 26/7/2019, and she was not instructed about the said opinion of the Foreigners Tribunal, Jorhat. Accordingly, she prays to permit her to withdraw permit the petitioners to withdraw the writ petition and to so as to enable the petitioner number 2, namely Anwar Hussain, to challenge the award passed against him. There is allowed. This writ petition is allowed to be withdrawn in respect of petitioner number 2 and in respect of petitioner number 1. Consequences of our observations are already made herein before. Next paragraph, according to this repression is allowed to be withdrawn in respect of petitioner number 2. Let the LCR be sent back.
Lordship, in respect to petitioner number 1,
We have already said that once he is registered, the consequences will follow.
Lordship.
You have
But
nothing more
in
to
the
do.
impugn judgment also, it was already reflected that after 10 years, he will be considered as an Indian citizen.
Consequences will follow. We don't have to say what is in the act.
But I had challenged the notice served to the petitioner number 1, Lordship, second notice that your Lordship may
No,
set aside.
pursuant to that, the proceedings completed, isn't it?
No, Lordship, second notice, Lordship. This is a second notice, Lordship. Page 34, Lordship, annexure 10.
To a second file. Second file.
For that only, I have filed this writ petition, Lordship. That is a fresh case, Lordship, FTG 1784 of 2011, Lordship.
Which page?
Page 34, Lordship.
You are allowed to appear and point out. You appear before the authorities and point out that it has already been decided, I am registered. Drop the proceedings.
Lordship, that is an, Lordship, harassment to the petitioner number one, Lordship. For that only I have filed this writ
No,
petition.
no, but then what is the status of this proceeding now?
Lordship,
FTG 1784, what is the status now?
1784.
1784, whether it was called for or not, Lordship.
No, it was not called for. Because the order is very specific. We have already called only with the records of 1781.
Lordship.
1784 was never called for.
In this writ petition, I have challenged both the notices, Lordship.
So we make it
It
clear
will
because
come
there's a
under
division.
res judicata,
Mr.
Lordship.
Chaudhary, please try to understand. There's a division bench judgment of this court declaring you to be confirming the declaration made by the tribunal that you are pre 25/3/1971. So once that is already declared,
Lordship.
there can't be a multiple proceeding. You have to just go there and tell the tribunal not to proceed with the matter. There's no harassment there.
Lordship.
It's just a notice.
Just a
Go and
notice,
point out.
go and point out. We make it clear in the order.
Lordship.
As petition number one is concerned, the last part, no? It is of the second paragraph is concerned.
Right, Lordship, I am also not aware about the outcome of that notice, Lordship. So whether we will keep it pending and call for that record or Lordship,
No, you make
I
a
will
fresh
take
challenge. If
instruction,
there's an
Lordship.
opinion against you, you make a fresh challenge.
Lordship.
That's very concerned. We take notice of the previous proceeding in respect of the petitioner number one. Wide FTG, by case number FTG of the 139/14 of the Foreigners Tribunal, Jorhat, wherein the said learned tribunal had already given its opinion that the petitioner number one was a foreigner who had entered India with Imperial Assam after what is the date? After 1/1/66.
Yes, Lordship.
1/1/66 and before 25/3/1971.
25.
And accordingly, the
1/1/1966 to 25/3/1971.
accordingly, the division bench of this court by order dated 7/9/2016 directed the registration of the petitioner before the FRRO from Jorhat. Jorhat and Nagaon.
Nagaon, Lordship.
Nagaon. Full stop. In this regard, the learned counsel for the petitioner has submitted that the second proceeding is a harassment to the petitioner. Next paragraph. As the opinion of the Foreigners Tribunal, Jorhat, in case number FTG /139/14, in respect of the petitioner has attained finality in view of the order passed by the division bench of this court in WPC 5174 of 2016. We provide that in the event the proceedings of FTG /1784/2011 instituted against the petitioner number one, namely Abul Kalam, before the Foreigners Tribunal, Jorhat, is still pending. Or the petitioner would produce the copy of those orders, a certified copy of those orders, before the learned Cornelius Tribunal, Jorat, would take note of the same and pass appropriate orders in light of the law well set in respect of the second proceeding against the same proceeding. Poster. Next para, needless to say that if the petition number 1 is still agreed, we will open to the petition number 1 to approach this court. This repetitions and disposal in terms of the observations made above.
I'm deeply apprised, Lordship.
Item 2 for motion.
Please, your Lordship. Yes, Lordship, the reference was registered in the year
What is the opinion? Which page?
Lordship. Page number 52, Lordship.
Which page is the opinion?
Lordship, page number, Lordship, 54 or Lordship, 54 last para, Lordship. And the in above, Lordship, and elaborately explain, Lordship, but there is, Lordship, and the tribunal was not suggested.
Just a moment. How did you prove this documents, service book, the NRC and the voters list of 1966 and 17?
And Lordship, and before the tribunal, Lordship, and he submitted, and subsequently all these documents are exhibited, Lordship.
No. How did you exhibit it? This service record, who exhibited that? Was it in original?
In office, Lordship, not with,
Huh?
in office, Lordship, not with me, Lordship, and even then not with the.
We are not getting, please repeat again.
And Lordship, service book is not with the petitioner, Lordship, and that
So
already been
who brought it? Who proved that?
it's proved by the Lordship, office, Lordship, and subsequently exhibited, but Lordship, and the petitioner was.
Exhibited is okay. For the third time I'm asking you, who has proved it? Who has exhibited that?
That is not done, Lordship. That is not done, Lordship, subsequently through office.
That is not exhibited.
Exhibited, but not officially, not proof,
Don't
Lordship.
tell us all these things. We are just asking you who did that. Tell us the name of XYZ. Don't tell us. Whether it was rightly done or not, we are examining it.
Not, Lordship.
Please tell us who exhibited this document. If you don't know, please be ready. We take it up next week.
Lordship,
Be ready because we'll be asking questions.
Lordship.
As the counsel for the petitioner is not prepared, this till the next week.
Lordship.
Item 3.
All the respondents are represented. Yes, sir.
Please, Your Lordship. Lordship, kindly adjourn the matter for a week, Your Lordship.
Just
There was fixed for consideration of the interim order matter.
this is a criminal petition. We can't adjourn it like that. You are aware of it.
Read appeal, my
No,
lord.
read appeal, Your Lordship.
This is the matter with regard to
Oh, acha, okay, okay,
promotion of a
okay.
person.
Oh, okay.
Senior.
Why you are seeking an adjournment?
Lordship, actually our file got misplaced by shifting our chamber, Your Lordship. So
Huh?
we have misplaced the file, Your Lordship, while shifting our chamber, Your Lordship.
Oh, in the first item we asked, we don't know the address of Sherlock Holmes. You are aware of it, the address.
Is it a good season to change chambers?
But we can't adjourn it like that. We can just give you 1 week's time, since you are saying that the chamber is being shifted,
Yes, Your Lordship.
not more than 1 week. Yeah, Mr. Saikia,
Matter fixed for consideration of the interim order.
you see what has happened.
Yes. One more issue, my lord, the gradation list, which was based on, my lord, by the learned single judge while delivering the judgment, my lord. There is under solence, my lord, in separate. That may be.
Please take us to that part of the order. But you see, in view of the observation of this court in this para 23 of the judgment,
My lord.
the impugn order, we can stay this order. What is wrong in this view of the court?
My lord, one issue was not considered.
Which one?
That was not raised also, my lord. The issue that the private respondent here in the petitioner, my lord, he was initially appointed on ad hoc basis. He was regularized in the year 2010, but his service has been counted since 1998. That period cannot be counted, the ad hoc period.
Just a moment. Just a moment. Who is for the school education department?
I'm Lordship, I'm appearing.
Oh, acha. So she is the main one. Without records, she can't address us.
Private responding.
Now, what has happened to this, what do you call this, consideration of all the eligible candidates? What has happened to that exercise?
We don't know that part, because the education can say that. Because he is sitting over, holding the post of the principal, my lord, in spite of the order from this court, my lord.
You have to fix a date. You have to fix a date.
Please agree to a date. Today is 23rd. We take it about 29 or 30.
30 may be appropriate, my lord.
29 will be better, my
Huh?
lord. 29 will be better, my lord.
29 is Monday, my lord.
No, for us, every day
29
is
is
a,
Thursday.
Huh?
every day, every time is a hearing day.
29.
If you are ready, we are ready at, even in the motion stage.
Let it be on Tuesday, my lord.
Okay.
30.
30 is not.
Also is a duty represented. Yes,
H. Karampi.
it's the Rampi, the historical to the education department. Has great for an adjournment on the ground that the with the, that he's shifting her office, for which she could not, she is not ready with the brief. First stop. Next one. The learned counsel for the appellant, as well as the learned senior counsel, Mr. give the names, Mr. I. Sekia for the petitioner and Mr. J. Roy, senior counsel, assisted by Mr. D. Das, counsel for the private respondent, have both submitted that there is some urgency in the matter. First off, as the matter is being adjourned at the instance of the learned standing counsel for the education department, we are inclined to provide that the exercise, if any, carried out in terms of the directions contained in paragraph 30 of the judgment and order dated 27/2/2024, passed in WPC 2066 of 2023, shall be subject to further orders that may be passed by the legislature. Next paragraph, based on 307/2024.
Item 4,
The petitioner's younger brother is a refugee. Actually, he's a Rohingya refugee. And he was caught in Karimganj.
Instruction,
because
yes,
he was
we
without
understand,
passport.
Rohingya, we understand that. What are the instructions from NEA?
So far as Lordship, the premise which this case has proceeded on, they want a deportation. Petitioner wants to be deported
Yes.
to Myanmar, Lordship. Now the identity verification was taken up. If your Lordship will come to the previous order dated 35/2024. I'll take your Lordship to paragraph 3 of that order.
Just.
Yes.
Which order?
Order dated 35/24, Lordship. Passed by this honorable court.
Yes.
If your Lordship will come to paragraph 3, the issue of nationality verification was taken up once before with the Lordship Embassy of Myanmar. There were 9 persons, but 2 were admittedly they were found to have stayed in Myanmar. But this particular petitioner was not found to have stayed in Myanmar. Thereafter, Lordship, it was again taken up with the Ministry of Myanmar in on February 26, 24. And recently a reminder has been sent on 6th of June.
You show a copy of the.
Basically, I am my brother's stateless, so it appears. So my only prayer, Lordship, this direction has been given by the Punjab High Court. Very many High Courts have given. Since UNHRC has given him the refugee status, let the central government write to them and they can come and take them, relocate them, whatever they do. You have given them status. And so let the central government write, because the government will obviously say no, Lordship. Myanmar government, I don't expect any favorable thing from Myanmar government. And who's going to verify where he is? So since UNHRC has given him a refugee status, let the central government write to them.
Right, to my.
UNHRC, and then take him, do whatever. And if he refuses, or at least give him access. Give him access with the UNHRC.
You were suggesting central government rights to whom?
United Nations Human Rights Commission. Because they have given him the refugee status.
So far as refugee status is concerned, Lordship.
Where is
India
that?
is not a
Where is
signatory to
that
the
document?
refugee convention.
Lordship,
Refugee status, where is that document?
Annexure 1 and Annexure 3 of my writ petition. UNHCR refugees card. And Annexure 3 is the certificate.
If I may just point out, Lordship,
Yes,
if your Lordship will come to page 12,
page
page 12, Annexure 1.
12.
Yes, Lordship, Annexure 1.
Yes,
Lordship will see just below the photograph.
yes,
This is a card issued May 2021.
yes.
Where was Lordship the petitioner Lordship? The petitioner Lordship was facing the trial at that point of time.
Please go to Annexure 3. That will clarify everything.
Because he was arrested. He was arrested in connection with a case of 2020. Then after the trial went on, Annexure 2 is a judgment whereby he was convicted. That is, judgment is of 9/5/22.
No, this was issued on May 21.
So when did he actually apply?
It was in May 21.
No, this was issued, the date is there.
It was
The
in May
date is
21.
26
So-
May 21.
21.
So
And the
After
date
that,
of,
I was arrested.
no, Lordship, the case is of 2020.
22,
2020.
22, 29.
no, you see, the entry is, Mr. Sorry, the entry is illegal.
Lordship,
Therefore, the trial and the conviction, correct? But the fact is that within this period of illegal entry, he applied before the UNHCR and was given a
That-
refugee status. This refugee status has already expired because of the 27/5/2023. The validity is from 2021 to 2023.
3.
So this is expired. But
So-
the fact is that if
I have
no, Lordship, question is, when he was under detention, did he have the access to apply? He was, cases of 2020, he will not be allowed to move free.
no, applications can be made by any means.
I-
Even the jailer, if you arrest X,
even
he
the
wants
brother would have
to
made
write
motion.
to the Ministry of
No,
to the ministry through the ministry to the UNHC. You won't deny that.
even let us assume Lordship, he has got a card. This, not the petitioner, petitioner's brother. Petitioner is also a Rohingya. So how is he outside?
How?
How is he outside Lordship?
No, that you
That-
that you can
that-
thank
that-
your government for it.
No, that
Let
is
the
what,
government
there
do
is,
that.
there is only a single statement in paragraph number 1.
No, but you see, the Ministry of External Affairs
Yes.
does not question the refugee status. Therefore, you are writing to the government of Myanmar. So you can't challenge, make a collateral challenge to this. You could have asked the UNHC, SCR to cancel this. The government of, Union government is not doing that. So they are accepting this status, and therefore you can't question in her petition, you can't question her document.
That is my, Lordship, personal,
No, that's
I
okay.
can- because
that's
I,
okay,
I could not
Lordship,
get the
you know
knack of
what?
it. One person is outside.
No,
No,
that is okay.
outside, that's, I'm outside, that's whatever may be the reason. Even you are not responsible enough that I could come out, roam around freely.
That is a question whether he's a brother.
No, no. We all
I-
read newspapers. We all see this in the news, correct? In highest security jail of the country, you find people with guns and mobiles,
Absolutely.
correct?
No. And Lordship, why do they want to keep me, feed me? Send me away wherever
No,
UNHCR
that,
gets.
if
they
what
so-
my
this-
senior is saying, that we have to do the same thing that the Myanmaris do. Put them on the boat and leave them in the sea. We can't do that.
No, I'm not asking you to do that.
No,
I'm
no.
asking you to.
That
to
is
give-
not what
No,
she is
that is-
wanting.
I'm not asking that.
Because
That's not
she
what
says
she's
he's
wanting.
he's from Myanmar. So until and unless the Myanmar government accepts him, I cannot send him to Myanmar.
No,
No,
that's why
sir.
you see, Mrs. Hazarika is making an offer. Your government can write to the UNST and they will take care of them.
Let them take care whatever they want to do. And if they refuse, I'll be there. I'll be here.
Lordship,
happy.
may kindly make a mention in the order, Lordship.
Ah, yes.
ಇದು ಬಂಗಾರ ಸ್ವಲ್ಪ আমার ಸ್ವಲ್ಪ ಇಲ್ಲಿ ಹೋಗಿದ এইবিলাক ফর্মালিটি নপৰে সেফটি ফর্মালিটি নপৰে সেইটো সুবিধা UNHCR party আছে না history of difference of the party. That's right. Difference
Yes.
Do you have any orders of another high court on this this issue?
What is the what is the likely decision or the step of the taken by the central government supposing no input comes from the neighboring countries, then what do you do?
Lordship, insofar as here is a case where there has been a judicial proceeding and the person is proved to be a foreigner
Hmm.
who has entered the country without any valid papers. Now, as per the Lordship, general circulars issued by the central government, Lordship, these foreigners cannot be allowed to move around freely, Lordship. They have to be kept confined in a particular limited place, Lordship.
But for which there has to be some order.
There are notifications to that effect, Lordship, issued by
No,
the.
no, you are relying on, you are saying that in terms of this order, page number 16, that's the order you are referring to.
No, this is the order of conviction.
Huh.
This
That
is-
is undergone already.
He has undergone.
Right.
Now, suppose we take it up with the foreign country and he is taken back. That is one aspect of the matter. The other aspect of the matter is, Lordship, he is the declared foreigner. That is proved by a judicial proceeding or whatever proceeding. A foreigner without valid documents is not allowed to move freely within the country. So they have to be kept confined and detained.
Where is it detained?
Now he says in Gwalpara.
Gwalpara detention.
Gwalpara.
Mrs. Harika, this does not help you because in this case, there's already an order to deport him to Sweden. Huh.
Where they have asked us to exit. Here they did not have the.
And that was, if what my senior is suggesting, that was a case which had come up before court number 2, Justice Koteshwar Singh was there, that point of time. I was a counsel in that case. There, they wanted access to the UNHCR for making an application. That was facilitated.
That is what I'm saying. They're given access. to
No,
the event.
now she already has a card.
So I want to tell them what to do. I mean, what is the bar locked in the central government writing? Instead of-
No, there's a reason for that. Because we are also thinking on the same lines. Because you see, you'll have to tell us. Can the court issue a direction to the central government to write to, because this is a policy of the government, to write to United Nations for facilitating his exit from India? Because whether the court can do that.
This is not a direction. The central government can explore taking up the matter with the UNHCR. I think that would suffice.
Because you see, for that purpose, we have examined, there are several decisions where say that like Mr. Chaudhary is saying, that he can have a safe passage from Guwahati to Delhi to make an application to UNHCR. So that part is already over.
In that case, Lordship, it was not even a safe passage. They arranged a video conferencing
correct.
from here.
Whatever
detention
is
center.
that.
Lordship, I have another decision, but I don't want to place it before Lordship, because it's from some thing which I cannot link it to the Punjab High Court. I can't link it to the official minutes.
Okay.
So I think it'll not be proper to place it on.
This card, did it expire in May 23?
23.
It has to be renewed.
So that renewal requires an application from your side.
Yes. So
So,
that Guwahati High Court can come in my way.
no, so you file your application.
If they allow me to.
They will-
She
they'll
has
fac-
already filed an
facilitate.
application under detention previously.
Then you can do it.
Let them allow me this now that I'm here.
No, they can allow you definitely a video conferencing and whatever application.
No, you have to file an application for that.
I filed an application before the day record. And they can consider it.
No, begin to record because then only we can issue a direction for enabling you to have a video conferencing with the UNHCR for extension of your.
I want to be with
Huh?
with my person law. Just give me detention or UNHCR would do something.
That
No, we'll examine this, let's just see.
You should require some examination.
Heard Mrs. M. Hazarika, learned senior counsel, assisted by Mr. D. Khan, learned counsel for the petitioner. Full stop. Also heard Mr. R. K. D. Chaudhary, learned DSGI for the Union of India. Next paragraph. Pursuant to order dated 30/5/2024, passed by this court, the learned DSGI has placed before the court and a letter and a memo number. This memo number so and so, dated 14/6/2024. The matter has been taken up by the Government of India with the Government of India from Ministry of External Affairs with the Embassy of Myanmar with respect to nationality verification of 9 illegal migrants, including the petitioner. And that the response of the Embassy of Myanmar is awaited. And accordingly, reminders have been sent to the Embassy of Myanmar on 26/2/2024 and 6/6/2024. It is also indicated that the Ministry of Home Affairs is the nodal ministry dealing with the subject matter related to migrants in India, the immigrants in India. Next paragraph. The learned senior counsel for the petitioner has submitted that as the petitioner holds UNHCR refugee card receipt bearing reference number page 12. You flagged it. Page number so and so. Dated 28/5/2021. She has suggested that the Ministry of Home Affairs may explore the possibility of taking up the matter with the UNHCR to facilitate deportation of the petitioner. Full stop. Next paragraph. We take note that the Embassy of Myanmar has not responded despite receipt of reminders dated 26/2/2024 and 6/6/2024. Comma. the court is inclined to provide that the Minister of Home Affairs can explore the possibility of interacting with the UNHCR so as to bring a quietus to the issue raised in this writ petition. In such manner as may be deemed fit and appropriate by the competent authorities. List on, we give you 1 month's time.
No, sure.
Today is 23rd. We take this matter on 28th of August because 2 or 3 days are holidays.
Yes, yes.
I mean, this informal option, like, the utility card has been reviewed. I've just got instructions.
No, that's okay. We are not writing anything adverse. List on 28/8/2024. For awaiting further instructions from the Ministry of Home Affairs and obligor Ministry of External Affairs. Now, this says MHA, this letter, but this UNHCR, who will deal with that?
MEA.
MEA only.
Lordship, since this is a nodal agency, MHA, let it be both, Lordship.
Huh?
Let it be both.
In the topic, right? MHA, where we have set it, MHA, Public Minister of External Affairs.
Lordship.
Central government will be appropriate to govern.
Huh?
Central government will be appropriate, union government will be appropriate to govern.
Oh, that is better. The government of India, through its
Appropriate ministry.
competent department. Don't write this to ministry, to its competent department. Just the learned DSGI shall send a downloaded copy of this order to the Ministry of External Affairs oblique and Minister of Home Affairs to enable them to route the matter to the appropriate department competent to take appropriate steps.
Lordship.
List on Swenson.
Meanwhile, you can also explore the possibility of them applying for citizenship. Is there any possibility? Because some decision has to be taken. I mean, it can be an endless process of detention.
The situation as of now is, Lordship. Anything happens, you come to India, Lordship. We are overpopulated, Lordship. We are.
So you take a policy decision. So therefore you have to take a policy, very concrete policy decision. Otherwise, they're not really criminals, antisocial.
If there are certain cases, if your Lordship, I not know whether your Lordship has come across. It's easier when you say you come from Myanmar rather than coming from Bangladesh. You don't have to face that FT.
Possibly.
There is another case which is scheduled to come up on Monday. They said Myanmar refugee coming, court evidence given in Bengali. So.
No, what, you see, what my brother is suggesting that the government of India should take a
Yes,
policy
no,
decision in the
that is-
matter.
That is a very welcome move.
Because
It
if
is,
you,
not
if
taken.
you find that they are of doubtful citizenship, not from Myanmar, then take an appropriate action. But when you stop at that, the question is the detention can be for how long? That's the issue which we are
Then
That
it's
is,
deal with.
that is,
taxpayers.
Worship has seen America, Mexicans. It's a situation in many countries, Lord.
We are not concerned with what other countries are
No, for
doing.
that we'll have to send both of us to a fact-finding inquiry. Because we'll have to look at ourselves and then,
And
Go to America, Lordship, to see how Mexicans are.
no, we can't suggest we go
You
there.
may recommend.
He may recommend.
and the number of detainees actually in Assam.
You take a policy decision. We are not saying that you are right or wrong. We are not sermoning. What we are trying to say is
What
that
has come from your lordship is a very good suggestion.
what we say that you take a policy decision so that some things may be given a rest.
Yes.
Otherwise, this will be aggravated.
That's the lordship.
And fact finding is always open.
America.
No, we don't know. Wherever government of India thinks fit.
Good luck.
Yes.
We are sending you this, Mrs. Hazarika,
Yes, sir.
these two judgments.
Item 6 for hearing.
May I please, Lordship? Kindly adjourn the matter for the day, Lordship. My senior Mrs. Yegan is out of station one.
Just some district 2017 matter.
That shows under this. Yegan. Respondent number one.
What wife and husband, madam? What wife and husband?
Just. You're appearing on behalf of?
A Grand Lordship.
We'll take it up next week. Should be prepared.
Lordship.
Because even otherwise, the CGC has hardly any role in the matter. Because neither you have contested nor you have cross-examined. So CGC has absolutely no role here. You're only a formal party. All sides are represented on the prayer made on behalf of Ms. A. Gandhi and CGC. The matter stands adjourned today. As far as this is a 2017 matter, list in the weeks commencing 29/7/2024. Fixing of the election. Take a short break and come back. Case 38, it's contested case. Yes, my lord. Here, my lord. The in judgment, there are in page 39. The documents and as well as the pleaded facts has been narrated under paragraph, second paragraph. Then, my lord, page 39, the documents has been discussed, it must been quoted, my lord. Exhibit A is the voter list of 1966 of village sworn number under circle season gram PS North Chalmara, where the name of parents of the proceeding Baksha Sheikh, son of Pataira, and the court Banu are from Baksha Sheikh. Exhibit B is the certified copy of the voter list of 1970 of village sworn number 6 under circle season gram under PS Savagiri, where the name of father of the proceeding recorded at Baksha Sheikh, son of Pataira Sheikh. Exhibit C is the electoral roll of 1985 village sworn number 6 and PS Hobigupur. Where the name of mother of the proceeding recorded as Bhanu Beva, proceeding's name is not seen. Exhibit D is the electoral roll of 1997, where the name of proceeding and his wife. Just a moment. In exhibit A, your father and mother are both there.
Yes, ma'am.
Exhibit B, your mother is not there.
Mother is not there.
Exhibit C, your mother is there.
Mother is there. Exhibit B, my lord, I think there may be missing by in issuing the certificate.
Pardon me?
Mother ought to have been there.
Where?
Mother ought to have been in the voter list of 1970. 1970 also.
70.
Yes, ma'am.
How you are saying that?
But mother name has been missing, but in 85 voter list, mother name is there in the same village.
But here their father's name is not there again.
Mother in 70 voter list, father's name is there.
No. 70, father's name is there, mother's name
Mother
is not
name
there.
is not there.
In 85, your father's name is not there, mother's name is there. 85, your father's name is not there.
My lord, 85 voter list.
70 mother's name.
70, mother's name is not there. 85?
My lord, record, in record there is 85 voter list, but we have not annexed in the writ petition. The record. Activate voter list, my lord, exhibit C. But we have not activate voters annexer. Voter list, exhibit. Activate voter list is 30.
When did
Yes, my lord.
your mother is alive or not alive?
My lord, at the time of my lord, the last stage of the my lord, at the time of filing of this petition, mother was reportedly alive. But
Mother was alive.
Reportedly alive, my lord. But whether alive or not at this stage, my lord, I cannot say.
But
mother is in 85 voter list. Father is not there.
So mother's name is not there again in 97 voter list and 2005 voter list.
My lord, yes, my lord. He shifted. The proceeding shifted from the original village, churn number 6. He shifted to Rakshasini, village Rakshasini, Garupara. And he alone shifted. Mother is subsequently remained in village Bharalkandi. I have annexed the voter list of Bharalkandi, my lord. Annexer 12. Annexer 12, page 42 is the translated portion. Mother is staying with other brother in.
Can't accept. You see page 19.
My lord.
19 is the written statement. There you say that you have shifted along with your family.
Family means wife, my lord.
No, I don't know.
It does not mean that he entire family, my lord.
I don't know. If we have to interpret the word, what is family then?
My lord, family means his wife. He is staying with his wife, my lord.
The respondent along with his family.
1990.
You are hearing it for the first time that the son and daughter may not be a family.
My lord,
son and daughters means also family, but it does not, my lord, clarified whether it is with mother, other brother or not.
No, if things are not there in the written statement, we can't understand your submission because part of the mind is here, part of the mind is hearing you. So when these two don't match, my lord, you put these awkward questions.
This is a written statement filed by you,
Written statement filed
giving
by
an
the proceeding.
opportunity to,
My lord, written
state-
statement is very, my lord, casual, my lord.
no, but that's the whole problem. Whatever
lord.
you have not
But,
stated in your written
but
statement.
what he has stated before the tribunal, that should also be considered.
Course, yes.
And in the evidence also, evidence chief and oral both should be considered.
Was there any cross-examination of witnesses?
My lord, I have not annexed, but in the record is there, my lord. I have also note down, my lord, from the record. It is recorded as I have born at zone number 6 under PS North Salmara, PS Pasonia, Post Office Pasonia, District Goalpara. Also brought up there. I'm the illiterate person. My grandparents, Fatera Sheikh. I do not.
Who is this Abdul Khalek?
Abdul Khalek is one of the co-villager.
So what is the name of the petitioner?
Petitioner's name is Jamaluddin.
Jamaluddin.
Yes,
He has been cross-examined. Okay.
He stated that I have shifted my residence from zone number 6 to Rakshasini. Here is because that he shifted alone and married with Sajiron Nessa of Parakandi. My mother, Podbanu Nessa, still alive, and now she lived at village Haralkundi. My father had no other name. I do not I have casted first book at Rakshasini in the year 1993. I never visited Bangladesh. Then my lord Abdul Khalek, he was cross-examined. He also deposed that he was born and brought up at village zone number 6. I know the proceeding from my childhood. He also took birth in the same village. He is an illiterate person. He's dealing with in spices business. His father's name is Badsha Sheikh. Mother's name is Kodmanunesa. Proceeding shifted from village from 6 number store to Rakshasini called Karopara Part 1 about 27-20 years. And exhibited 3, 4, 6, 7, 8, 9 documents. 6 documents and one was annexed. The chief and the cross-examination part goes to show that he has made claim that his parents were voters in 1966-70. Mother is voter 85. Subsequently, my lord, although voter list of the village Bharalkandi could not be produced during tribunal, but we have annexed in the writ petition that mother is alive up to 2016.
Mother was not produced as a witness.
Not produced as a witness. And he is voter in another village. So, my lord,
But you see, Mr. Siddhar, the evidence, you have a copy of the evidence of this Jamaluddin, the examination chief, evidence in chief. You have a copy of that?
my lord, examination chief is with me, my lord, but no cross-examination.
No, it's okay. Now you see, second page, paragraph 5. My lord, name of my parents are recorded so and so.
See, my lord.
Xerox copy. Yes, paragraph 5 of the evidence. Evidence in chief.
My lord.
Paragraph 5. He proves a Xerox copy of certified copy.
Xerox copy of certificate voter list
Yes.
is enclosed here with.
So he produces a photocopy, correct? Now this Abdul Khalek, he comes, he also exhibits a photocopy, exhibit A, B, C.
My lord, whether the photocopies are compared or not with the original, whether that part is in the my lord, documents mentioned or not, that should be looked
No,
into, my lord.
compared copy is still a photocopy. You have to show us that this photocopy is otherwise admissible.
My lord, in the judgment, the tribunal said that 70 voter list certified copy. And
No,
exhibit A
you
is the
see,
voter list.
Mr. Sikdar, whatever we are reading, we are just telling you.
My lord.
In the evidence in chief, they say it's a photocopy. Correct. Now, the document which are here, you just check this. We are
Hello.
putting flag on in this evidence.
Written statement of লিখেছে, it is as it is photocopy করে দিচ্ছে, test করে দিচ্ছে, এটা কত বলবো।
Here is the trial court records. You put two flags.
My lord.
You see, the first flag is the evidence.
Yes.
Turn over to next page, paragraph 5. You will find.
Yes, my lord.
Xerox
That I have
copy.
seen, my lord. That is
Correct.
there.
Now, turn to the second flag. This
Yes,
is the document
Xerox
filed by Firisti
Xerox copy.
and all Xerox copies. And look, the documents are also there, all Xerox copies.
My lord, there is a note cropped in original.
Hmm?
Cropped in original note is there. In the both 66, 70. In D also.
Mr. Pang, you want to go through the records?
It's no matter.
It will. Actually, very good. Yes.
Which document are you relying on specifically?
My lord.
Which documents are you relying on to furnish the link?
My lord, the voter list of 66, 70.
Only that?
85 voter list of mother, my lord. And one co-villager has supported his claim. There is a positive statement that
No, but-
parents
But the certificate of the secretary was never proved.
not, that is done. But his positive statement that my parents were voter in 1966-70, I was supported by another co-villager. And that positive statement is
No,
never
but the mother itself,
denied.
mother herself does not support you. Mother did not come as witness.
My lord, the mother, I don't know, my lord, whether mother was in condition to come or not. But
You are the son, you can tell us. Whether the mother is.
prima facie, my lord, my positive.
No, you will
statement-
not be able to tell us because in the record we have found somewhere, you said that the mother is living in a separate village.
Yes, my lord.
Now you don't take care of the mother and mother doesn't take care of you.
My lord, these people are, my lord,
No, I don't know. What
lord,
are these people? I don't know. I don't have.
our
personal
area,
knowledge.
my lord, when face some problem from the river, they want someone shifted according to them.
No,
to
that is
some
okay.
place.
No, that is okay. But
He
you see,
shifted to village Rakshasini Garupara.
no, that's okay. But somewhere you have made a statement. I can't recollect where I have read, but there is somewhere where you have stated that I think in your evidence, you said that you alone shifted in a different village.
Yes,
So therefore, and you say that your mother was in a different village.
yes.
Now, she's a voter of village X. She is a resident of village Y.
No, mother remain, when he shifted, mother remained in the original village.
No, no, no. Please check
Subsequently,
up your
mother
evidence.
mother in another.
Please check up your evidence. Somewhere you have stated a village. I don't know what name is that. Is it your cross examination? Because I won't remember.
Yes. Yes, sir.
Is it in your cross examination? You said that I alone shifted and your mother remained in your village. What is the name of that village?
Rakshasini. He shifted to Rakshasini.
No, what your mother? You were.
Mother remained in Boralkandi. Mother, I shifted alone. I married Sajiran Nasa.
No, but this village is
mother
not-
had mother
this-
Padmani still
this-
alive.
no,
Now
that-
live.
That village is not the original village. Number
Yes,
6.
that village is also not original village.
Then
He stated that my mother Padmanu Nasa still alive. Now she lived at village Boralkandi.
so that's a different village.
Different village.
Unconnected. So therefore, you have to first demonstrate that you are you are these people are your mother and father. Merely by voter list, it doesn't prove that he is the mother and father.
Journalists will prove that
My-
these
my na-
persons
my-
are there in that particular constituency. You'll have to furnish the link.
My lord, against my name, my father's name is in the voter list. So prima facie indicates that I am the son of Baksha Sheikh, and that has been supported by another co-villager. My lord, what is the material against me, my lord? That is also to be looked into. What is the materials against me?
That is what we are asking you.
That
What is the material in your favor?
yes, my parents were voter in 1966-70. And my lord, I being a river person shift here and there. My mother also shifted, and therefore, my lord, for shifting, my lord, everything, my lord, will go, my lord. My parents are voter in 66, 70, 85. My mother is voter. Mother still voter, but in a different village. And that is supported by a positive statement of myself and by another co-villager, my lord. Where is the, my lord, rebuttal evidence to my claim, my lord? They have not even cross-examined. And Lordship may kindly have go through the report, how the case has been brought up. The inquiry report is false. They have collected some statements, some persons. As per the full bench judgment, after recording statement, signature or thumb may be taken. That was not taken. How that can be believed, my lord? So, my lord,
Was it
my lord, in the report.
was it taken up before the
My
tribunal?
lord, it is a legal question, my lord. It can be raised here before this court also. It's a legal questions. And the Supreme Court in a recent judgment, my lord, in Rohim Ali case, has clearly said
the executive is not in authority to pick up any person to randomly. They cannot pick up some definite information or materials to be collected against the person whom doubted as a foreigner. That has been this decision in the Rohim Valley case, very recent
No,
judgment.
but that is the very basis why the matter has been sent to the authority, the foreigners tribunal.
Lord. But-
And these
but-
are issues you
but-
never
but-
raised.
But what is the my lord, material?
These are issues you are supposed to raise before the tribunal.
My lord,
To say that there is no material.
my lord, the people facing these people and the advocates who are conducting the case, if they fail to raise this issue in the tribunal stage, whether that cannot be.
That is why we call them learned.
That should totally,
That-
my lord,
that is
buried
why-
well.
That is why we very honorably call the lawyers a learned lawyer.
My lord.
We can't find fault unless you show us.
My lord, one line is the WS, my lord. The respondent, the delegation imposed upon the respondent by the complaint is flatly denied by the respondent, which is baselessly instituted against the respondent only for harassment. The one line is there, they baselessly, it is framed, my lord. So that is enough, my lord. We are, my lord, we have to go to the materials, to the prosecution case, how the case has been framed. And when my positive statement not being denied, no rebuttal evidence that this person is not my father, that is the finding of the, that is the observation of the full court, full bench judgment, my lord. In paragraph 117.
Where is that?
My lord, in full bench judgment of the Muslim Mandal case, my lord. Lordship, I have only one copy, my lord. In full bench judgment, kindly have a look, my lord.
No, when the matters are listed for hearing,
Well,
we would request learned counsels to at least furnish a list of books that you want to rely on. We are not asking you for copies, but what judgments you want to rely on, so that we also get an opportunity
my lord,
to.
if Lordship, my lord, take up, my lord, any other day. I could not prepare, my lord, all the.
From your
No,
submissions, it appears you are very well prepared.
My lord, my lord.
Which paragraph of Muslim Mandal?
Muslim Mandal, my lord, 117, my lord. My lord, 117, sub-para 3. May I read out, my lord? I
Yes.
put it the judgment, my lord, in the second half, my lord.
Yes.
My lord. 117, sub-para 117.3. For the purpose of recording the opinion as to whether the appellant is a foreigner within the meaning of the 1946 Act, the appearance of the appellant number 1 himself, witness number 3, and his wife, namely appellant number 2, witness number 4, is relevant. The appellant in his deposition has stated on oath that in the relevant electoral roll of 1966, his father's name appeared at serial number 60. Against
Yes, carry on.
against holding number 6, part number 15 of village Kumulipara under number 50 Gorpeta. The said electoral roll has been proved and marked as exhibit S. The appellant has also deposed that his mother's name also appeared in the said electoral roll exhibit S. That apart, the appellant number 1 has also proved the copy of the national registration certificate 1951 as exhibit E, containing the name of his father, Shukur Mahmud, whose name appeared in exhibit F, electoral roll of 1966, exhibit G, electoral roll of 1970. The NRC of 1951 reflects the name of the appellant number two's father Abdul Gofur issued by the competent authority and marked as Exhibit N. The relevant electoral rolls of 1970 containing the name of Abdul Gofur, who according to the appellant is the father of the appellant number two, has also been proved and marked as Exhibit O. The state did not challenge the aforesaid version of the appellant number 1 and 2 during their cross-examination. The said version of the appellant therefore remains unrebutted. Then, my lord, 117.4 is also same in the same speed. Then, my lord, 122.1 is also same in the same speed, my lord. But this paragraph 122.1, which you are showing, in the middle, it says that the appellant also could prove the certificate issued by the village headman, Exhibit 5, as Exhibit F, certifying that the appellant is the daughter of Sahib Ali. The appellant therefore proved that her father's name is Sahib Ali, whose name appeared in electoral roll of 1966. Therefore, the legacy was proved by showing that the
My lord,
lady is the daughter of Sahib Ali.
My lord, I have examined another for villager, my lord, instead of village head. My lord, so in the light of the 1173, my rebuttal, my positive statement has not been rebutted. That being the position, my lord, only because my mother's voter list not produced, the tribunal has taken a negative view. My lord. Whether that can be fatal to my the prime evidence, 66 voter list, 85 voter list, my mother's name is there, my brother's names are there.
Shows
So
the
that can
finding.
be fatal, my lord.
Shows the finding which is against you.
My lord. Page 38, which starts at the opinion, my lord.
Page
Is 13, my lord. Lordship may kindly have a look at page 40, the decision and reason for the decision. Page 40, decision and reasons for decision. Lordship got it, man. I have perused all exhibited the proceeding and the documents relied upon by the proceeding, and after perusal of the same, it is found that although the proceeding exhibited electoral roll of different electoral rolls, electoral list, but there is no explanation that when his father expired, and the proceeding willfully avoided to exhibit any electoral roll in between 85 to 93, as because as per the proceeding statement, he shifted at succession. In the year 1990, moreover, the proceeding in his cross stated that his mother is still alive and lived with another brother, but the proceeding failed to produce any documents relating to her mother. The proceeding stated that he is now 50 years old and he is of 50 years old, then his name is to be recorded in the voter list of 85 or 93. But the proceeding failed to produce the same. Moreover, there is no documented proof except the link certificate, and the said certificate is not proved through the person who issued the said certificate. Therefore, only on the basis of link certificate, it cannot be believed that the proceeding is the son of Baksha Sheikh and Korbanu of Sor number 6. Therefore, the point number 1 and 2 answered against the proceeding. Hence, the proceeding totally failed to discharge the burden as my lord, no discussion as regard the positive statement, as regard the rebuttal evidence of the state. My lord, only because I failed to produce the voter list of my mother and the proof of the Panchayat certificate.
Not elaborately discussed, but.
Yes, Mr. Payal.
My lord, first of all, I'd like to show your lordship the WS, my lord. Your lordship will find the WS, my lord. Look, at piece, my lord,
Shastro, page 18.
page 18, my lord.
Yes.
Your lordship will find para 3. It is that the respondent, one of a citizen of India by birth and born in and brought up at village number 6, Salt, my lord, during approximately 1965. So if he was, that is his statement, and as per my lord affidavit also, he was 50 years in 2017. So his date of birth, he is eligible to cast vote sometime in 1989. Because at that time, 21 was the year age for casting a vote, my lord. After 85, it is, my lord, 18. So in between 85 to 89, he is eligible to cast vote. So it is very important, my lord, 89 is very important, 89 and 93 voter list, because according to him, he shifted in 1990 from that village. So if he shifted in 1990, if he had a documents of 1989, that means which he could have, because he is eligible to cast vote it from 85 to 89, in between this period. So if he had some documents of those period along with his parent, that was the best document. But intentionally, that was not produced. Those were not brought into the record.
How do you see intentional?
No, my lord, because, my lord.
We can say it was not there.
No, it may be there, my lord, but it is not brought because why I'm saying, my lord, this is intentional because he has said that he shifted in 1990. 97 documents he could brought it. 85 documents he brought it. But why 89 and 93? This is intentional because if he brings, my lord, 89 voter list.
Mr. Payal, you can look at it in a different way. You see, number one, the A is the father of B.
I understand.
That is in 1966.
66.
That fact you don't deny.
I don't deny, my lord.
Correct. So therefore,
A is
even if the subsequent voter list, the one of the entries of the father or mother is not there, doesn't change the factual parametrics.
I'm not on that, my lord. I'm not saying father and mother is not there.
No. You see, what is so adverse of a voter list not being exhibited? Does it mean that he is not a citizen?
What I'm saying, my lord, my submission is that he has shifted in 1990 in a different way.
Please come to the your election manual. Please tell us the manner of updation of a voters list before the election. What is the procedure? The procedure is that there is a house-to-house enumeration, and the persons who are available, their names are entered. Now please tell us that you are here today. Let us assume that house to house enumeration is going on and in your house you are not found. What happens? Your name is dropped. And therefore, when the voters list is, what you call it is,
Prepared.
no, not prepared. It is called draft is published. Then you get an opportunity of
Correction
correction.
correction.
Correct. So if
Madam,
somebody does not,
I'm not on that. My submission is that, madam, he said, but he shifted in 1990.
no, let us assume that you are right.
Yes.
He is not intentionally brought in.
But I mean,
How does it change the factual matrix?
that's why I'm saying, madam, let me submit in that point, madam. If my lord, he said he shifted in 1990. We accept that he shifted 1990. Then in 1989, he should have been there in original village, my lord. If he was there in original village, why the tribunal has said, if he was in the original village in 1989, the father, mother, whoever is there, other family members, his name should have been there in 1989. That's why he could have brought that would be the best evidence. My lord, but I'm not saying it may not be fatal, but my lord, to link himself. Now, after shifting, he has voter list in 1997 at New Village, my lord. Now we have to link. My lord,
you have to tell us something more. Please presume that since we are taking this determination since yesterday, we are not updated in the legal what you call finisher of these things. Now please tell us, under which provision of law can we draw a presumption that if the entry of a particular year is not there in the voters list, citizenship is lost?
I'm not saying, but to link himself
I
with documents here.
You see, whatever be the voter list of 1985 is not there.
Not there.
Correct.
That doesn't mean he will not be citizen, madam. I'm not saying. Yes.
So therefore,
I admit that.
even if the father's name is there, he does not prove it. His mother's name is there, does not prove it.
Does not prove it.
The question is that in 66, the state or the Union of India does not deny the correctness of the voter list.
66, one person is there, my lord. We have to, my lord, we accept in 690, here lots will find 66 voter. One Bacha Sheikh is there in 1966. 1971, Basa Sheikh is there, 70. We admit one Basa Sheikh was there. Now, my lord, our point is only thing that whether he is son of Basa Sheikh or not, Basa Sheikh or not, to link that proof, to prove that link, what is the document?
Show you something.
That's never been challenged.
No, that is
State has not objected that this.
No, my lord, that's why, my lord, it is the duty of the petitioner to prove that that person is my father. Where is that proof? Yes. No, where is
66 and 70?
My lord, 66, 71 person is there. Basa Sheikh is there.
70, sorry, 85.
85 he is not there along with parents. 85 is not there along with parents.
You say this.
2005.
2005, father is not there, mother is not there along with the petition. No, father is not a voter. Name is there, my lord. In a different village. In a different village, father, he is. So how can we presume, my lord, that Basa Sheikh and Bacha Sheikh, whom he has produced, shown as his father in 2005 and 1997, is the same person? We cannot presume, my lord. It is the petitioner to say, prove that yes, this is the same person. If he can prove, yes, I am the son of Basa Sheikh, whose name was there in 1966 and 70. That is enough, my lord.
Sending you something. Read 50. 50.
Yes.
Please read loudly. We'll refresh our memory.
Yes, my lord. This is opinion on relationship when relevant. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship or any person who, as a member of the family or otherwise, has special means of knowledge on the subject is a relevant fact.
There's
Provided, there is a provision, my lord, provided that such opinion shall not be sufficient to prove a marriage in a proceeding under Divorce Act 1869, or in prosecution under section 494, 495, 497, 498 of Indian Penal Code.
Correct.
Yes.
So therefore, you see, Evidence Act excludes the opinion of marriage.
Yes.
You can't give evidence and say that A is married to B. That evidence can't be led. There can't be a presumption of marriage because by an oral evidence.
Yes.
This is one part. But it does not say that this presumption would die if the connected voter list is not there. A witness comes and tells that he is the son of so and so. Now, with this statement we made, that since we are not updated in the case laws on the point, please tell us, is there any case law where section 50 has been interpreted by this court saying that one of the voter list not being there would extinguish the presumption
Yes.
or opinion of someone, of a witness of the village, who said that he is a son of so and so?
My lord, there are numbers of judgments where it is said the oral evidences would that regard.
First one.
Two, three judgments are there, my lord, I can.
No, whatever it shows one.
This is one judgment, my lord. This is not reported probably. My lord, this is WPC 1900/2019 of this honorable court.
Pass on the copy.
Next piece, my lord, para 6. Smart. TW2. She was the mother. Double G. This thing is 19. Another judgment in the next judgment also on the same line, madam. In the same compilation.
We don't know, how does this observation help you? You see this, paragraph you are making us read. It says the statement of DW2, Jaharun Begum, who claimed to be the mother of the petitioner, cannot be relied upon in absence of any document showing her relationship either to the projected grandfather, father, or to the petitioner herself.
Yes.
Correct. So this is what has come out. Now, in this case, there is a document. That is 1966 voter list. Has some connection.
My lord, that's
No.
why what my understanding is, my lord, 66 voter list is there. In this case also 66 voter list was there. Here, my lord. But the son has a voter list of 1997. But to link themselves in between, my lord, mother has come.
No, in this case, in this exhibit 6, which is the voter list of 66,
Yes,
mother's name is not there.
yes,
Therefore, when mother comes and says that I am the mother,
yes.
the court disbelieves it because there's no link either to the grandfather or to the father.
My lord, next one is also next judgment.
No,
on the
next
same-
one is again, next one is again father. We have
Yes,
seen
yeah,
that.
further.
Once we were seeing that, we looked into it. Now you see here the statement of Amiruddin, who
Yes.
claims to be the father of the petitioner, cannot be relied upon. This is the finding.
Yes.
Now,
In absence of documents, the link the petitioner and the my lord father.
yes,
Here,
but here you see what happens is that the voter list of Amiruddin is of 1971.
Yes.
So the requirement is 65 and 70.
Yes.
Not 71. And therefore the court says we don't believe your oral testimony.
that is not the issue, my lord. What my submission is that probably what my understanding is in both the judgment, my lord, the petitioner, the father has come before the honorable court tribunal and given his deposition, and but father could not prove, my lord, brought any documents to link himself to the son, or mother could not link himself, brought any documents to link herself to the son. So for that reason, my lord, that was not accepted. Evidence of the DW rules. Further, my lord, this is another judgment of this honorable court. And this, yes, I'll submit the details in this.
Give it us so that we are prepared.
Yes, ma'am. Yes. Actually, my lord, that's
Because
why,
the second judgment, you see why the court is disregarded is the entry in the Jamabandi. In the Jamabandi, the name of the father, Exhibit 5, is recorded as Amir Hussain, whereas he was projecting that the father's name is Amir Uddin. Therefore, when Amir Uddin came and said that he is my son, the court disregarded it because of the fact that the
that is one of
name
the
in the Jamandi is Amir, again I forget the name, Amir Hussain.
Amir Hussain. That is one of the ground, my lord, but mainly, my lord, whether oral evidence can be accepted.
No, it's not a
To
question
link-
of oral evidence. Please come again.
Because
See, we are repeating this question, we rise for the lunch, but the question is that if the state and the government of India, central government does not dispute the entries made in the 1966 voter list, where is the case that there is no document to link the petitioner with his father? You see, in one document of 66 and 70, which is admissible,
my lord, I'm
the
submitting this.
name of the
Your
father
lordship.
is there. Let us assume that in all the voters list he is not there. In 2022, his voters list, his father's name is reflected. 23, 24, 24 election, the
Yes,
father's name is elected. For even if for 20 years or 30, 40 years, if the father's name is not reflected in any document, does one become fatherless son? So whether for every year one has to prove, where is the law which says that every year you have to
No, I'm
update
not-
the name of your father in the portal?
We are not praying, my lord. We are not asking for that each and every year there should be at least one document with the petitioner along with parents to link each another. At least one document in between this period. Which is that document?
No, you have to tell us the mere oral evidence.
Yes,
Without any supporting document.
documents will not do, my lord.
Will not. Show us a
That is this judgments, my lord, that
The judgment is not an authority only on that point.
yes.
This has to be read on the. attending
Other
facts.
contexts are there, my lord, but there are numbers.
Sir, give us one case law which says that that evidence on record can be disregarded just because one voter list is absent.
No, my lord, we are not asking that. We are
No,
not.
no.
praying, my lord.
Once you are
That
raising a
one-
legal
one
issue,
voter list. Yes, yes,
we have to understand it legally.
yes,
You are raising a legal issue.
yes.
So if the legal issue, you see, a judgment is a
If-
authority
my
on
lord,
the,
if-
on the facts on
I'm
which it
submitting
is
this
decided.
judgment, my lord. If your lordship see the judgment, this will give some clarity, my lord, in that regard. Because here it is said.
You
if some-
continue to because otherwise
yes,
we'll not be able
yes,
to
my
come
lord,
in
yes.
time.
At too much. My lord,
I'm just asking you a question. My questions and examples are always horrible. Correct.
Lordship, that's not
Yes.
horrible, my lord.
Yes, one more horrible suggestion. Now you see, you forget that you are here.
Yes.
You assume that you are in this side.
Yes.
Correct. You change the tables.
Yes.
Yeah, you just suppose for the time being that you are in this side. Now we take up a writ petition. In writ petition, A comes and says, A, aged about so and so years, son of B. And then we hear the matter. We don't ask any question. And then we dismiss the writ petition on the ground that he has said that A is the son of B, and there is no document to show that the B is the father of A. And on that ground, we dismiss the writ petition. Now tell me, being in this side, how will you like it? I don't put a question. I'm a judge who doesn't ask any questions.
Yes.
I take up the matter and then in the instead of going on merit, I dismiss on the ground that the evidence of B being the father of A is not there. That is one way of looking at it. There's a second way of looking at it. You see, had there been, let us see in this case, what is the reference?
Yes.
In the reference, what is the father's name? Jamaluddin Sheikh, father's name is late Badshah Sheikh.
Yes.
Therefore, this person was never called upon to prove his lineage. Now, therefore, please tell us, when this is not in question, when the border police goes investigates, now you can't come up and say that the border police did not go and investigate at all. So he filled up this form 1. In this form, he says that he is the son of Badshah Sheikh. Now, where is the question of the of onus on the petitioner to prove that he is the son of Badshah Sheikh?
May submit, my lord. Yes. Because, my lord, I understood, my lord. In normal case, my lord, if I say I am the son of so and so, we generally accept it. My lord, this is not the case. Normal case. Here, the very question is that. Very question, my lord, fact in issue is itself is that whether he is son of that person or
No,
not.
never.
And whether he is.
No, the question is whether he entered into India illegally after 25 March
That is the issue, my
1971.
lord. Generally,
Unless you show that this is a question formulated, that what is his parentage,
yes.
for the issue to be decided.
My
I
lord,
find
for
it
the-
very difficult.
yes, your lordship may kindly see the Somananda Sunal para 26. What is
Para
para
26?
Yes. Para 26 of the Somananda Sunal 1, my lord. 2005 5 SCC 665.
Several Sunwal 1.
Yes, 2005 5 SCC 665.
Yes, paragraph
26. my lord. Lots of things.
SCC.
Yes.
TV2, TV. এখনো অন করে দিও রাজি এটা অন করে দিও paragraph
Para 26, madam.
26. How does it start?
There is a good and sound reason, madam.
There's one paragraph which starts from this, the state of Assam in its affidavit. How many paragraphs plus or minus from there?
That is prior to that.
Prior to that.
Yes.
There's a paragraph which says it is very important to note here that IMDT Act does not contain.
Even prior to that, probably, madam, it is-
Even prior to that.
Yes. That is para 40 as per SSC, my lord.
Okay.
Yes. It is important, my lord, that your lordship has seen that important note that the IMDT Act does not contain. My lord,
Just a moment.
yes,
The provisions of IMDT Act may now be examined.
prior to that also.
No,
Prior
prior to
to
that. Okay.
1, 2, 3, 4,
There is
5.
good and sound reason.
Yes,
Okay.
from there. There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of particular country. In order to establish one's citizenships, normally he may be required to give evidence of number one, his date of birth. My lord, these are the evidence to be given. Number one, his date of birth. Number two, place of birth. Number three, name of his parents. And that has to be. Then number four, the place of their birth and citizenship. That is with regard to parents, citizenship, and sometimes the place of birth of his grandparents may also be relevant in under section 6A1B of the Citizenship Act. All this would be necessarily be within the personal knowledge of the person concerned and not the authorities of the state. The facts, after he has given evidence on these points, the state authority can verify the fact and can lead evidence in rebuttal if necessary. This is. So what needs to be proved before the tribunal, madam? First of all, date of birth, place of birth, citizenship of their parents, birth, place of birth. This everything has to be proved. In fact, in some cases, with the grandparents may also be necessary, madam. But so that is the very point, madam. Now, as your lordship has seen, madam, with regard to collection of materials, the lordship has seen that piece para 40. It is very important to note that as your lordship has seen in just sometime back, madam, sometime before, para 40 it is there. Some observation of honorable Pax Code in that aspect, madam.
This one, paragraph 48.
Yes, 40, madam.
40.
This is important because, my lord, we have to accept one thing, my lord. The present proceedings are coming from the IMDT tribunals. These were initiated during the time of IMDT. So all 40. All these, my lord, references are coming from IMDT, and the enquiries, my lord, enquiries were done during the time of IMDT. Now, the Honorable Apex Court in IMDT, my lord, setting aside the IMDT, has said these informations, the Form 1 and Form 2, where the informations are necessary, my lord, this cannot be ascertained by the investigation officers because they may not give the details. The proceedings may not give the details, and they will not give. Why do you give? one person who is coming illegally from Bangladesh or other world, he will not give details that I'm coming on this date, I'm coming for this reason. He will not give. So Honorable Apex Court,
It
Madam,
is
para
very
40
important to note.
yes,
In the ambit of this not contain provisions.
para 40, my lord. It is very important to note that IMDT Act does not contain the provision similar to Section 9 of the Foreigners Act 1946 regarding burden of proof. On the contrary, it is conspicuously silent about it. In such circumstances, a very heavy burden is cast upon the authorities of the state or the appellant to establish that a person is an illegal migrant to define under Section 1C of the IMDT Act and is liable to be deportation. That was, my lord, in the IMDT. Now, para 41, it is said, my lord. Rule 4 requires an inquiry officer to elicit information and particulars from the alleged illegal migrants on the points mentioned in form number 1, item 5, 10, 11, 12 of these forms as under. These are the, my lord, part of the forms which the investigation officer collects. My lord. Address of the country of origin, village, police station, district, and other country. Does the person hold any passport issued by the foreigner country? If so, furnish particular. What are the reasons for leaving the person's country of origin? If the person has entered into India without a passport, how the person entered in India, name of the village and districts of the person, date of entry. It is elementary that this observation mechanism. A person who has illegally come from Bangladesh to India and is residing here for his better economic purpose or employment, etc., would never disclose that he has come from Bangladesh, but he would assert that he is an Indian nation and resides in India. There is no question of telling the date of entry or giving the information on the aforesaid points. Then there are other requirements also, this which may not disclosed by the proceeding at the time of inquiry. Now, what my submission is that, my lord, in fact, we have a judgment of this honorable court that mere mentioning the father's name in the notice or in the reference, it will not prove that he is the son of that person. Because that is a prima facie notice given to him. The inquiry, while going for inquiry, police make an inquiry to the person concerned, and he will disclose that I am so and so, and my father is so and so. Whether that fact is correct or not, we cannot know. We have to record what is given by the proceeding. So mere recording in the proceeding that he is son of so and so in the police proceeding may not be exclusive proof of his he is the son of that person, because it is recorded on the basis of his statement. So that is one issue. Secondly, my lord, what my submission is that in the entire present case, my lord, we are not disputing that one person was there in 1966 and 70. We accept the projected father from the, what is the name? The Batsa Sheikh or Basa Sheikh. There is dispute Basa and Batsa. There are some disputes. Even their ages or age are not matching, my lord. There are some, I'm ignoring those disputes, my lord, minor discrepancies. But one Basa Sheikh or Batsa Sheikh was there in 1966-70. We admit, my lord, we have no dispute on that. We want, my lord, that the petitioner has to prove that he is the son of Basa Sheikh of that particular village, son number 6. Now, my lord, suppose, my lord, I say the Basa Sheikh is my father, who was there in, my lord, 1966 and 70 at, my lord, son number 6. And in 1990, I shifted from that village. I'm residing now in Guwahati. So being son of Basa Sheikh, I'm a citizen of India, if I say. And I have somehow enrolled my name in the voter list in 1997, showing Mr. J as son of Basa Sheikh. Is it possible on the part of the state to disprove that? But it is not possible on the part of the state to disprove. It is if I intentionally puts my name in 1997 voter list by saying that I'm son of Basa Sheikh and in a different village without linking any documents to that person. That's why I'm saying, my lord, if the petitioner has said that he shifted in 1990 from that village, if we accept, then why he could not produce voter list prior to 90, my lord? Because he was eligible to cast from 83 to 89, 90. If he could bring a documents of 89, 85, where the petitioner along with his parents' name appears, it could be the best evidence, but he did not bring it. He only narrated that I shifted in 1990. My lord, he has not said why his name was not included in voter list prior to 1997. He has not nowhere explained, my lord. Nowhere this is explained.
Mr. Payan, we have more than 25,000 cases of foreigners traveling here.
Yes.
How many? How many?
Here
more
about
than
25 cases, 25,000.
Now, does the state not realize that it would be appropriate to put it in the rules?
Rules.
What is the nature of proof to be done? Like the civil procedure code, you have a procedure, you have civil code rules and orders. You prescribe how the things are to be moved.
Well, that is lack on our part, my lord, probably on the part of
So
the
you
state.
see, number one, please tell us. We are repeating this question again and again.
Yes.
In 66, he is the son of Badshah Sheikh.
Yes.
Correct. Now, in 1997, he is the son of Badshah Sheikh. So in the meantime, if his father, the entry in the same voter list of his father and the son is not there, whose son he was during that period?
No, my lord, I'm not saying. He's shown himself as son of Badshah Sheikh only in 1997. Prior to that, there is not the documents. He was 32 years in 1997. Prior to that, there is no
Under the
not the
citizen, you see, please concentrate on this Citizenship Act and the
My lord,
the Foreigners Act.
I have submitted
you
one
please-
judgment of this honorable court, my lord.
And you please show us that is it a mandatory provision where a person, in order to demonstrate himself to be a citizen of India, has to mandatorily get himself enrolled in every
My lord, in
voters
fact,
list?
if his name is enrolled in the voter list also, he may not be a citizen of India. He may not be a citizen of India. That is also, he may not. My lord, your lordship may kindly see, this will some clear your lordship probably from the para 10 onwards in this judgment, my lord.
Paragraph?
Para 10 onwards. My lord. This is the situation where, my lord, the exact position, how it is to be proved has been, my lord, described. May I read, my lord? Para 10.
Yes.
From the reading of section 9, it is apparent that the onus of proving that the proceedee is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall lie upon the person, notwithstanding anything contained in the Evidence Act. In other words, burden of proof that the proceedee is not a foreigner would lie upon the proceedee himself or herself in proceeding under the Foreigners Act 1946. In order to discharge such burden, if the proceedee relies upon a particular given person whose name appears in either in voter list of 1966 or 70, or whose name appears in a particular and loan documents pertaining to the said period, or relies upon other acceptable and admissible documents which establishes the existence of such person within the territory of India during the relevant period, that is prior to 25/3/1971, the discharge of burden of proof as required under Section 9 of the Foreigners Act would be that the proceedee concerned would have to prove his lineage to the particular person whose name appeared in the aforesaid documents pertaining to the period of 25/3/1971. Although Section 9 of the Foreigners Act 1946 provides that the onus of proving the proceedee is not a foreigner lie upon such person, notwithstanding anything contained in the Evidence Act of 1872, but in order to understand the concept of burden of proof, we may still rely upon the concept of burden of proof as provided under Section 101 of the Evidence Act of 1872. Section 101 of the Evidence Act of 1872 provides as follows. Yes, it is quoted, my lord. Then para 12, the concept of burden of proof as provided under Section 101 of the Evidence Act, it is that whoever desires any court to give judgment as to any legal right or liability depends on the existence of the fact which he asserts must prove those facts exist. In the case in hand, under section 9 of the Foreigners Act, the existence of fact which would be required to prove by the proceeding is that the concerned person whose name appears in any aforementioned public documents or the documents relied upon by the proceeding alone is the lineage of the proceeding. As a corollary, any evidence being laid in discharge of such burden of proof, who should indicate the lineage of the proceeding to a person merely having the same or similar name as that of the person appearing in the public documents relied upon, in our view, would not be sufficient to discharge the burden of proof to establish the existence of the fact that the person named in the referred public document constitutes the lineage of the proceeding. In order to discharge the complete burden of proof, the nature of the purport of the evidence must be such that the lineage is established not only with respect to the person whose name appears in the public document relied upon, but at the same time rules out the possibility of being linked to any other person having a same or similar name.
Just finally, don't know how this is helping you.
My lord, my
How the judgment is helping you, you see,
yes.
we start from paragraph 20 in this judgment. Paragraph 20 of this Regional Bench judgment,
Yes.
2019-1 GLT 784. We start from paragraph 20.
Yes.
According to the petitioner, failed to discharge the burden that she is the daughter of so and so.
Yes.
Correct.
Yes.
This is
Whose name appeared in the
this is saying
1966.
now. In this case, we find from the reading of the entire judgment that in this case, there is no voters list of this lady with the father.
Same is the case, my lord.
No,
Here
no, no. Let me complete, otherwise you won't know where I am going.
Yes.
Now, this
the facts are stated here. We find from this in para 17,
Yes,
para 16 of Rufjan Begum is quoted.
yes,
Now, the certificate of GP
yes.
is disbelieved.
That is not proof as it
Correct.
was not true. So it
Now-
is.
Now, you come to paragraph 3. Three is the documents which she has proved, and para 4, in order to establish the linkages of Sovan, the present case of father, Reliance was certificate issued with Sarkari Gaon Bura.
Yes,
So this Sarkari Gaon Bura were disbelieved.
yes.
Then come to paragraph 7. In paragraph 7, there's no record that the Gaon Bura was asked to be a witness.
Yes.
But that principle will not apply in case of the DW2.
That will not
What
apply.
TW2 the petitioner can bring. So therefore, paragraph 8 says that the Gaon Bura certificate is disbelieved.
Yes, and it was not proved. He didn't come forward for proving it, my lord. It was disproved.
There's a point that's still not satisfied.
Yes, what my submission is that, my lord,
We put this up on the next week. In the meantime, you give us a list of books in advance. You, what do you call?
yes, ma'am, I'll give the list of
This case laws where it is developed, that despite 66 voters list, like one you have shown us,
Yes.
shown before us. Give us a list of, you don't have to give us a printout.
yes, I'll
Give
give,
the court master in advance the list book list. And you also, if you have any case laws, you
My
please
lord.
give a book
Yes,
list in
my
advance.
My lord.
We are taking it up in next week.
I will also furnish a short written argument also.
Fine, do whatever you want.
Judgment also.
But don't make your written argument more bulky than your written
No,
itself.
only the
Ah.
point wise, my lord.
Ah.
Only
On
point.
the point where don't elaborate.
Whatever
because-
I submitted today, my lord,
So
So whatever you submitted is recorded.
My lord.
You just give a bullet point, don't make your, what you call, don't give a, what you call,
Explanation.
a written argument.
My lord.
Make it bullet point means bullet point, don't make it a.
Only my lord, bullet point, my lord.
And the case citations, give this in advance.
My lord.
But Mr. Here, signal on the counsel for the petitioner. Z time, understand because for the Home Department. From Mr. G. Sharma, then it. Committee advocate. Oh, and Mr. HK Hazarika. For study for respondent number 4. So the argument remains inconclusive. List again on next Tuesday.
My lord. Next Tuesday.
3/07/2024. We are returning back this citations. Give us a list of books in advance. Mr. Pang and Mr. Sharma, these issues will come in every case which we are dealing. You please give a book list in course of the day today, because from
I have submitted the list of, I have submitted the list.
give a list of books. Just give us the list of books.
No. I have submitted.
Just add those and give us, because in most of the cases we'll require this same set of decision. Now give us a list of books, that will be okay. Okay, please hand it over. Let me see what are those. Action. This is the updated case laws, or this was the one which we prepared earlier for court number 4.
Updated.
Updated, okay.
You're keeping it? You want, I have given it, this is draft. I have submitted.
It's okay, once you have given it, you get it. That's all. Realize it. Okay.
But also can keep it also. So it's okay if you submit it with your books.
Okay.
Item 8 for hearing.
Good. Next is your lordship.
This review petition, I have challenged on some grounds that my grandfather's, there is a discrepancy in the name of the grandfather lordship. So page 5, it starts the grounds lordship.
Your grandfather
Name is-
died when? What is the date when your grandfather died?
Lordship, that date exactly not mentioned, but there are some discrepancy in the name of the.
No, that's okay. You don't have the date of death of your grandfather? Does his name appear along with along with you in the any voter list?
No, lordship.
No,
My name appeared along with my in-laws family, lordship.
the in-laws family.
Yes, lordship. She is Manwara Khatan. Her name did not appear along with her father, lordship.
Along with the father.
Yes, lordship.
Now,
Her name appeared after her marriage, lordship,
after her marriage.
along with her husband, lordship, in the in-laws family, lordship, not with her father's family, lordship. To prove linkage, lordship.
Just all.
Written statement of over.
This. Just a minute. 724. Go back. Something is again wrong.
Lordship.
Something is wrong. You have a copy of your written statement?
Yes, lordship.
You have a copy of your written statement?
Yes, lordship. Page 37 of Annexure 17.
No,
of
I am
my
going through the LCS, therefore I'm not aware of this
Lordship.
documents. You please come to the affidavit appended to your written
Written
statement.
Only verification I have.
No, after that there is a affidavit. You see the trial court. My difficulty is that I come from a very bad place. Yes, this is the affidavit in support of the written statement. She is 33 years in 2007. So she is not growing. She is 36 in 2021 in your writ petition.
2017, 33 years, lordship.
Yes,
2017,
17 or 7? 17.
17, lordship.
Okay.
17, 33 years,
So
lordship.
17 and 21 is 4 years. 33 for 37. Something is 36 now. Okay, I wrongly read it. That means
Lordship.
I am reading it 2007,
2017, lordship.
2017. So she is born in 1984.
Yes, lordship.
She is
She-
born in 1984. Therefore, if her name is not with the, she will be 18 in 2002.
2002 or 3, her name ought to have been appeared, but her name appeared in 2010, Lordship. That is one of the ground, Lordship.
Okay.
And school certificate, she have annexed, Lordship, but she has made a statement that that ought to have been shown as 1984, but school
And
certificate.
any
shows-
document of your father?
Yes, Lordship.
There's no document exhibited of your father.
Yes, Lordship. Voter list of 1985.
Exhibit 12 is the Gram Panchayat certificate.
Yes, Lordship.
That is for you.
Yes, Lordship. The voter list of 2008,
Gram Panchayat certificate goes because of the Ashok use of
not called the GP
emblem.
secretary. Yes, Lordship. There is emblem. Moreover, we have not
No, but
proved,
still it
Lordship.
is otherwise not proved.
Yes, Lordship.
So then your link to your father is not proved.
Lordship, one land document was there, Lordship. Will was made in favor of the petitioner, Lordship. That was not taken into consideration by this Honorable High Court in the judgment as because,
No, because
was-
will is prepared after the reference.
yes, Lordship, to prove
it's a
that at
created evidence.
father, he himself deposed as DW2, Lordship. Father's documents are already annexed, Lordship, 1985, 1997 voter list. And grandfather up to 1970, Lordship. From 1951, Lordship. 1951 is NRC document, Lordship.
Because this affidavit becomes a self-declaration.
Lordship,
This affidavit becomes a self-declaration.
Lordship,
That X is my son, X is my daughter.
Lordship.
That relationship can't be the basis of an opinion.
The GP certificate was there for showing linkage to the OP to her father, Lordship. That was not proved and national emblem was used, Lordship.
No, that's okay, but once it is not proved,
Lordship,
so that evidence got, there's no link.
Lordship.
Because if there's no link, then we will have a problem because Supreme Court in many of the cases have said that the High Court in a writ petition shall not reappreciate the evidence.
Lordship.
Because you have to bring it in the category of perversity. That if that was not, that if the evidence which ought to have been considered and not considered, the amount of perversity. So once this perversity is not there, then we are bound by the Supreme Court judgments as followed by this court.
Lordship.
That
Then if your Lordship wants to hear on this and I am not prepared, Lordship, on the regard that.
no, you see, in this courtroom, we have told you 100 times.
Lordship.
At the motion stage, I am ready for hearing. Admission stage, I am ready for hearing. Order stage, I am ready for hearing. Hearing stage also, I am ready for hearing. So if you have to take an adjournment, take it in the first blush.
Lordship.
Don't wait for the court to enter into a what do you call examination of records and then tell us that we are wanting adjournment.
Lordship.
This is really not appreciated.
Lordship, if your Lordship kindly accommodate on Thursday, your
No,
Lordship.
no, accommodation is okay, but you see, today this would be the fourth case when we start up. Even yesterday, 4 cases were adjourned because it was not prepared. If you don't have preparation, please tell us in advance and then take an adjournment and go.
Lordship.
But don't what you call test the court and then say I want an adjournment.
Otherwise, Lordship, the grandfather, there is some discrepancy in the name of the grandfather.
No, but that's the first question we asked you.
Lordship.
You have no voters list along with your grandfather.
No.
You have no documents to show about your grandfather. Therefore, we'll have to presume that you were born after your grandfather died. Correct, because even your father, please show us voters list of
Father, Lordship.
Of the father, where is that?
Lordship, that is paid.
Sometime in 80s and 90s. What is the
1985, Lordship.
1985?
Yes. Father and mother, Lordship.
Father and mother.
Yes, Lordship.
That means the father was, your grandfather was not there in 85.
No, Lordship.
Correct. We are presuming that. So therefore, you see, you were born in 84. You did not see your grandfather. We presume that you did not see your grandfather, and therefore you can't say that there's a discrepancy in the name of your grandfather. Because that would be hearsay evidence.
Lordship.
You don't disclose the source of your knowledge. From whom did you derive knowledge that your father's grandfather's name was this, wrongly spelled as that? Who gave you that information?
Only, Lordship, in written statement and in evidence in chief, there is a declaration that there are discrepancy in the name of my Lordship. There are,
But how do you know, in first place,
Lordship.
that your father's name was different?
That was specifically.
Well, I
not
did not, you see, I was 6 years old when my grandfather died. So my father told me that my grandfather's name is this and this. I remember only that. So today to come up and say that my grandfather's name was wrongly spelled, how do I get that knowledge? It has to be hearsay evidence. Hearsay evidence is not admissible.
So what was your grandfather's name?
Polan Sheikh, Lordship.
Polan.
Polan, Polan.
Now, if you come to the affidavit in evidence in chief, by who is Anwar Sheikh? Sheikh?
My father.
Come to his affidavit.
I, Anwar Hussain, son of late Polan Sheikh.
Palan.
Lordship. PALA.
And your statement in para 4 of your written statement,
Lordship.
you are giving so many aliases. Polan, Polanodi, Palwan.
But against his name, his father name is shown as Shahed Ali, Lordship.
Whose father?
Mother of great grandfather, Lordship. That Shahed Ali was correct in all the documents, Lordship. In the writ petition, also in NRC document, Polan Sheikh against his father's name, column, Lordship.
No, unless you link yourself with your father and your grandfather,
Lordship.
whatever is the name, is a bit too far.
Lordship.
So first, if you can connect yourself to your father, then we go back to the grandfather.
Lordship. For that,
Because you see, just to say that the name of the grandfather is in paragraph 9, you have said Polan Sheikh, Polanuddin Sheikh, Palwan.
Lordship.
So this is there was some source of information. It can't be your knowledge.
Lordship.
You never knew.
From the information derived from the other family members, Lordship, from my father, that was though not specifically stated in the written statement in evidence also, Lordship.
Because I remember long back, it's in a lighter note.
Lordship.
Long back when I was not I was not in the bench. So one day my son told me that one of your childhood friend has come. I said, how do you know that he's my childhood friend? No, he rang up and asked me, when I opened the gate, he asked me, is that idiot inside? So he told me that except for your school friend, nobody will call you an idiot. You're a good lawyer. Nobody would call you an idiot. He must be your childhood friend. So therefore, my son could presume that somebody who is my childhood friend, he has not seen him. but the connecting is a slang that was used.
Yes.
So you could connect it and then tell me that your childhood friend is there. Because nobody else will tell you that.
His lordship, there was no such.
Because if, no, you see, there must be something documented that the name of X is has an alias of Y has an alias of Z. So otherwise, you take a telephone directory. Earlier we had Calcutta telephone directory was in one volume. Bombay full telephone directory was in 2 volumes. You just search for a name and then just pick it up and then make it your address. Because you must have some source of knowledge of the grandfather having 2 aliases. Because all these statements are true to your knowledge.
Lordship.
So please tell us, how do you have the knowledge that your grandfather had 2 aliases?
That was not
You
specifically
do not know it.
in the written
That's why I get
statement.
this horrible example.
Only in written statement and in the evidence in chief, it is stated that these are
No,
the
you've just
same
seen.
person.
We did not have the knowledge, but Mr. Payang just placed before us the Sarwar and Sonwal one.
Lordship.
It says that you have to prove the lineage. So that's why we are now molding our questions. So if the lineage and the parentage is required to be proved, he's discarding the entries made in the form, saying that this form, even the Supreme Court has discarded it. They could not have, that is not sacrosanct. Therefore, even if a reference is made, as per the projection made by Mr. Payang, the entries are still required to be proved by you by showing your lineage. It's not a case where, when we gave an earlier example, when you said that A is the son of B in the affidavit, in a writ petition, that example is bad. Now, because of the projection made by Mr. Payang, that Supreme Court says that you have to prove your parentage. That is why now we are changing our question.
Other than this, lordship, 17 documents were exhibited, but lordship, to show the.
No, you see, you are correcting it. First, you say that your grandfather's name is so-and-so Sheikh.
Lordship.
Then you come to a different, what you call, voters list, where there's a entry of name of Palwan. And then you say that your grandfather's name has an alias of Palwan.
Lordship.
So therefore, you are correcting it. So therefore, you'll have to show us, not based on the 1960, this, what you call, voters list of 1964 or 66. You have to independently show that there is a man called Palwan and he is your grandfather.
Lordship, against his name in every document, his father name has been shown as Shahid Ali, lordship. That is only one connectivity, lordship.
No, you see, merely because we get a name of, let us say, we take an example again. We come across a name of, let us say, Muhammad Ali.
Lordship.
Does it make him a boxer, Muhammad Ali, from United States?
Lordship. But in all the voter list.
Because the names are common. These names are so common and so commonplace, those names, that you have to establish otherwise.
And along with Palwan's name, his own brother's name was also there, lordship. Muhammad Ali Sheikh, and against both of them's name, lordship, their father was shown as Shahid Ali. In all the documents since 1951, NRC document I have annexed, lordship, in my writ petition.
No, we are not saying that it's a false document. No, for a moment, we are not saying it. We are just wanting you to connect yourself to that.
Lordship. To show that connectivity, only the will was prepared by my father, lordship, in my favor, and father, he himself deposed as DW2.
Will his exhibit number?
exhibit number 17, Lordship.
What is the date of that will?
Date of the will, Lordship, it was 2016. Will dated 24/7/2017, Lordship.
Pardon me, what is the date?
24/7/2017. Exhibit number 17. I don't think I got the instruction. I will have the lunch this minute. This was really the title of the file. But thank you.
Have you introduced this document in your written statement?
That will, Lordship.
Yes.
No, Lordship. In written statement, annexure up to 15, Lordship.
Then under the Mohammedan law, in order to give effect to a will, the property must be alienated. And the donee must be put in possession of the property.
Lordship.
So in 1/12/2007, when you file your written statement, your father did not divest himself of the property and you were
No,
not in
Lordship.
possession.
Written statement, first day of February 2017.
Whatever be, I don't memorize. Maybe you are,
Okay.
I am wrong. But but therefore, how did you introduce this document?
Will was executed subsequently, Lordship.
Okay. So there's no additional written statement made.
No, Lordship. Yes, Lordship. The pleadings were already in the Lordship written statement that I am the
But without
daughter
written
of
statement, you could not have introduced an evidence.
Lordship. Pleadings are there that I am the daughter of so and so. So to prove that linkage, Lordship, it was elaborated by way of GP certificate.
No, we told you we are not aware of the law. Please tell us if there's any decision of this court saying that a document can be introduced without there being a reference in the written statement. Oh, acha. Just 3 o'clock. We'll take it up next week because there's a single bench we have to take it up. Other matters to be adjourned. One matter, that's not. Make it next week. This till the positive time matter, the hearing could not be concluded. This till the week commencing 29/7/2024. There's one more matter left. We adjourned that also.
Obliged.
Yes. Okay, because I think this matter also will take some time. How much time, Mr. Dasgupta?
Minimum half an hour to 1 hour.
Otherwise, we don't pass any orders, we'll adjourn it.
If it remains that, it will make. Nothing I'm paying for 8th of August.
8th of?
August.
8th of August. Yeah, good to go. Okay.
All right.
Just check up after I rise. I'll be rising at 4:30, 4:15. No, you're not required right now. Just come and inquire with the court master after 4:15. I'll be rising at 4:15. There's a meeting at 4:30. Yes.
In fact, my lord, I already replied. So, what I was suggesting was to be without, highly written argument and.
That would be most welcome. Because over a period of time when we break the bench, it's very difficult to recapitulate again.
Suggesting plan.
No, if you can do it, it's well, but you see, both you are senior counsel, I can't request you to.
No,
That's all.
I think.
Most convenience is our convenience because we have to satisfy your lordship.
No, Mr.
Both of
Dasgupta.
us.
No, Mr. Dasgupta, the problem is that when the determination changes, like today we are in, I was in the division bench with taking a foreigners matter. They told it new determination. You have to recapitulate and then.
Yes, that is correct.
Like this, my lord, let us both file, and then your lordship will fix a date, my lord, then, that is not take much time. We'll file a very short written argument.
No, I filed my list of dates. If required, I can add my.
You suggest a date, both of you.
Any date you have also convenient.
No, you
because
choose the
I have-
calendar there, because I am giving an option because I'm really tied up. I can't.
Yes, sir.
Because for me, every day, Mr. Dasgupta, I'm here. It's your convenience we want to take care of.
Because your lordship knows that there is a division bench matter. Your lordship already fixed that is Nagaland matter. That is 22 days. After that, they.
And you see how difficult it was to start hearing.
Today I am ready, prepared, but because I have to prepare again for that. I have to assist Mr. Datto. Till then, Miller, I have to hear it.
Let it be on the second.
You both agree to a date?
14th or 16th of August.
Prior to that, it can be.
Or not.
Both of you agree to a date. For me, every day is convenient.
I am today I am fully prepared. Anyway,
Let it be on 12th.
Yeah, anytime. Mr. Dasgupta is there.
Monday.
anyway, only after that two dates that your lordship already fixed, the Nagaland matter.
What are the dates? I won't remember.
Yes, fixed is 30 and 25th.
25th and
25th and 30.
30.
Okay, so after that.
After that.
When?
I said, it will be 12th of August, Monday.
No, instead of that, can we fix it on the week commencing 5th?
Yes.
Because next, what will be the determination, we don't know.
Yes.
All right, then.
But then that will be better.
Week beginning on 5th.
So making the 6th, if required, it can be.
Right.
6th of Naya cool. At the outset, Mr. A. Dasgupta, the senior counsel, assisted by me, Ms. B. Das, learned counsel for the petitioner, as well as Mr. P.K. Roy, learned senior counsel, assisted by Ms. A. Chakravarti, counsel for the respondent, has suggested that as the matter is being intermittently heard, they would prefer to file a short synopsis of argument and then make their oral submissions. Full stop. The said proposition is accepted. Next part is agreed to by both sides. This matter, this part and matter on 6/8/2024. It's really difficult to shift from one.
Yes, sir, that is very
determination
difficult.
to another.
Fully appreciable point. Very difficult. After all, we are human beings, not computers.
No, Mr. Dasgupta, the